Welcome to Court Helicopter Explainer over the weekend. It is a big relief to the family of the late Judge, Justice David Shikomera Majanja. May God rest his soul in eternal peace. This is a man who developed the jurisprudence of law in this country. Judge Majanja was a commissioner of the Judicial Service Commission. Justice Majanja led a serious life. From the will, Justice Majanja comes out as a serious investor. Even if he was doing his job, he also invested heavily. The judge died without a husband, without a wife, or without a child. And the matter went to succession, and succession was concluded at the first time. Yesterday, the dispute that arose has been resolved. In the case of, in the re-estate of Majanja, alias David Shikomera Majanja, deceased, succession cause number E800 of 2024, Justice Riech gave a decision in this matter. And these are the brief facts for you to understand. The deceased, David Majanja, died on the 10th day of July 2024 at a Nairobi hospital. On the 2nd of September 2024, Joseph Nduku Kihanya filed a petition for grant of letters of administration with a written will annexed on the grounds that he was named as an executor of the deceased's will, which was dated 21st June 2014. Majanja wrote a will dated 21st of June 2014. He appointed Joseph Ndungu Kihanya as an executor. Then he moves on to say, he annexed a copy of the will of the deceased. On the 17th day of December 2024, a grant of probate with written will was issued to Joseph Ndungu Kihanya and Steve Biko Lusenmo in their capacity as the executors of the will. So the will was attached, and the court on the 17th day of December 24 granted the probate. The executors filed summons for confirmation dated 18th July 2025. The same was heard by this court on the 21st of July 2025, and all the 7 beneficiaries consented to the confirmation. This is very critical because we want to understand why was there a dispute. The judge is saying on 21st July 2025, all the 7 beneficiaries appeared before the judge. They consented for the confirmation. A certificate of confirmation as per the will dated 21st June 2024 was issued on the 21st July 2025. So all the 7 beneficiaries appeared before a judge, and all of them consented. Very, very critical. So where does the dispute come from? The judge proceeds. The court noted that some of the deceased properties which form part of this estate were not in the will. As the judge was dealing with this matter, it is the judge who detected that some of the properties are not in the will. The 7 beneficiaries were not aware of these other properties. How did the judge take judicial notice of this? Remember, the judge knows very well that there are pension schemes, and the judicial, once you are a judge, there are benefits you get as a judge. Upon you dying, they were not included. So the judge says it was noted. What happened? By consent of the 7 beneficiaries, the court appointed Gershon Lugitio Majanja, the father. By consent, they appointed the father and Jenard Louis Muhagi Majanja as administrators of the deceased's estate properties. So the 7 accepted by consent to appoint the father of Majanja and one Louis Muhangi Majanja. The administrators then informed court that a total of 15 properties formed part of the estate. The court directed the administrators to file summons for confirmation within 30 days. They were not able to do so and sought that court grant them another 45 days to do so. Before they filed the summons, Mr. Murage for Martin Alvisi filed an application dated 5th October 2025 seeking a declaration that pensions funds and life insurance proceeds are chosen in action and therefore payable to Martin as per the will. So, as they are waiting to file their papers, Martin made an application that the pension of the judiciary, the benefits of Majanja from the judiciary should be given to him alone, excluding the 6. Very interesting. Very, very interesting. Now you understand where the dispute of Majanja's estate arose. He goes on to say, this court, by ruling dated 11th February 2026, dismissed that application and declared that the deceased, having not nominated beneficiaries in pension funds and group life insurance, those funds formed part of the intestate property. So the question that has been delaying this issue is that Martin wanted the pension funds, the judiciary benefits to be given to him alone. And yet, the will did not say that. So the court listened and asked him, produce evidence to show which will gives you this property. He could not produce the will. The court dismissed that application and declared that the properties outside the will not be dealt with the will. They will be dealt with as properties intestate. We have taught you that intestate, if you die and you have not willed your property, the court will look at the will, ignore it, and look at the properties, divide that property equally among the people. And that is what the court dismissed Martin's application for being greedy, for being selfish, for being self-centered against the other 6 beneficiaries. Remember, this Martin never worked in the judiciary. Remember, this Martin never put any input in the production of these properties that were acquired by Justice Majanja. So the judge said those properties will be distributed as properties of the intestate estate. And how has the judge, the judge has distributed the properties like following this order. The property has been given 1, some properties, Jenard Louis Muhangi Majanja, he has been given 1, a property in Isuha, Kajiado, and Maela Ndabiri. Janet Masita Majanja has been given 1 property in Kisumu, Ojola 6691, Kisumu Ojola 6692, Kisumu Ojola 5781, Kisumu Ojola 5780, Kajiado 1583, and Suba Kitawa 48. The third beneficiary is Annette Lutivini Majanja, Isua Lubao 4856, 4845, plot 48 in Kibos plus plot 177, plot 177 Kisumu Sheria. Then Martin Jesse Majanja has been given Isua 2109, Lukenya 599223 stroke 31 6335, Kisumu 5977, Alan Hamadi Siema Mavoko 93393, Kisumu 5995, Maela block 233333. The Generals Louis Muhanji Majanja, together with Janet Masisa Majanja and Annette Lutivini Majanja, they have all given in common by the named beneficiaries and in equal share to Ishua 5544 and Kajiado 14298. Then the judicial properties. This is where the dispute was. How has the judge distributed this property equally as the law of intestate succession says? To the father, Gerson Lujito Majanja, he has been given a group life assurance policy held at the Judicial Service Commission. Share of hair 10,200,000 to the father. The father has been given a lion's share. Remember, the father is diabetes, the father is old, the father is having medical challenges. The father has been given shares of 10,200,000 at the judiciary. The other people, that is Gennard Lewis, Janet Masita, Annette Lutivini, Martin Jesse, Alan Hamadi, they and Garrison, all these have been given 2.2,408,268 equally. The others have been given equal shares of 2,408,268. Then the pension held by the National Social Security Fund has been given to Gerson Lujito Majanja, the father. That is the property. Then the motor vehicles has been given to the father, Gerson Lujito Majanja. The vehicles and shares at the pension held at the National Social Security Fund. This is the judgment, dated the 13th day of March 2026, signed by Justice S.N. Riech, a judge of the Family Division of the High Court of Kenya. The battle is over. The judge makes a very interesting finding. Why? The person who was making this complaint to court to stop the distribution of the estate was part and parcel of the people who consented. He forgot that the court records, and the court justice, the judge Riech says, a perusal of proceedings in this file shows that on the 21st July 2025, in the presence of all the parties, the court recorded. This is what the court recorded. This court has confirmed distribution of properties in the will. This court notes that there are properties not in the will which will form part of the estate and be managed as intestate. Louis, the first beneficiary, He raised his hand and said, I propose Gerson Majanja to be the administrator. Priscilla, I propose Gerson Majanja. Janet, I propose Lois Majanja. Martin, I propose Gerson Majanja. Annette typed, I propose Lois Majanja. What did the court say? Upon hearing the beneficiaries, except Alan, this court appoints Gerson Majanja and Lois Majanja as administrator. Parties to file summons. So, the parties, Lois, Priscilla, and Martin proposed Gerson Majanja to be an administrator. Annette and Janet proposed Lois Majanja to be an administrator. The court appointed the two that were named. From these proceedings, it is clear to me that the appointment of the administrators was proposed by the beneficiaries. The applicant Gerson was also present and he had no objection. Therefore, the process of appointment cannot therefore be said to be defective. Clearly, a petition in this estate had been filed, gazetted, and there was no need, in my view, for another petition. Gerson appeared, and Gerson was present. He never objected. So, the court is saying this was a waste of time. This was an embarrassment on the family of the late judge, but it has been settled now. We hope, and from Court Helicopter, we seek the family not to appeal, to move further to the Court of Appeal to challenge this matter. We wish to thank the judge for settling this matter in a fair, just, and lawful manner. Each party has been catered for. 1. Those of the will has been implemented without an alteration. 2. The properties that were not in the will, they have been distributed equally. People will ask, why has the father been given more? The father has more medical complication. The father was a dependent of the judge. All the medical bills were being taken care of the judge. We wish a good ending, and it has come to an ending. We have kept an eye over the succession battles in the Justice Majanja's matter. As we advised, this was not a matter to go to court. Remember, any of the application that was in court has been dismissed. There was no merit to fight. By consent, the properties were distributed by consent. Wakili Dan Stanomari, always a pleasure to do what we do best. Thank you and enjoy a lovely